Okay, let's unpack this. Imagine a legal saga that feels straight out of a true crime documentary, but it's happening right now in the very serious environment of a U.S. Court of Appeals. Today, we're taking a deep dive into an urgent legal motion filed by none other than Joseph Maldonado-Passage, who I think many of you know better as Joe Exotic or the Tiger King.
Yeah, what's fascinating here is that this isn't just, another filing. It's a critical new legal push. The motion itself actually calls it the fourth installment in his appeals. But they make a point right up front, saying Maldonado-Passage is hardly a vexatious litigator.
Meaning he's not just suing constantly for no reason.
Exactly. They're underlining that this isn't some desperate shot in the dark.
Yeah.
They point to his successful direct appeal that actually got his sentence reduced back in 2021. So there's precedent for him winning on appeal.
Right. So our mission for this deep dive is to really pull out the key stuff from this pretty dense legal document. It's called a motion for rehearing en banc, filed August 1st, 2025. And en banc, for anyone maybe not familiar, means he's asking the entire 10th Circuit Court of Appeals to reconsider a decision that was made by just a smaller group, a panel of judges.
A big request.
Huge, yeah. And we're going to look into this bombshell new evidence he claims would have gotten him acquitted. We'll dig into the allegations that the previous court ruling actually contained false statements and explore these really complex legal arguments about how new trials should work, especially, when witnesses suddenly change their story. Get ready for some surprises, I think.
Definitely. It's a fascinating look at the justice system's gears turning.
So let's get right into it. The core of this appeal, the thing his team seems to be betting the farm on. Maldonado-Passage's motion really centers on what it calls newly discovered, highly material and relevant evidence. They're using the word bombshell, claiming it plainly would have, if disclosed at the time of trial, resulted in Maldonado's acquittal. That's a huge claim. What is this evidence?
Well, the biggest piece, the one grabbing headlines, is the recantation by Alan Glover. This is the guy the prosecution called a hired hitman. He testified against Maldonado-Passage.
The star witness, essentially.
Pretty much. And the motion says Glover has now admitted, under oath, several really critical things. First, he says, and I'm quoting here, committed perjury during my trial testimony regarding my involvement as the hitman in the murder for hire.
Wow, okay, just flat out admitting perjury.
Flat out. And it gets more specific. He also apparently stated he was rewarded for his testimony, which is the opposite of what he said at trial. He claims, they told me during trial prep that if I did what they asked, then no charges would be brought against me. An undisclosed deal, basically.
And what about the money? The $3,000?
Right. The motion argues that the $3,000 Glover got wasn't payment to kill Carl Baskin. Instead, it was merely a loan or payment to enable him to relocate away from Maldonado's former zoo.
So not murder money, but getaway money. That completely flips the script on that piece of evidence.
It fundamentally undermines the reliability of that whole part of the case.
Yeah.
And it's not just Glover. The motion also includes sworn declarations alleging the undercover recordings.
Oh.
The ones used against Maldonado-Passage.
Yeah, I remember those are key.
They argue those recordings were carefully shaped, crafted, and manipulated for inculpatory effect. Inculpatory meaning edited or presented to make him look guilty. And furthermore, the motion claims the true nature and context behind the recordings were both hidden by the government and the witnesses and exculpatory, meaning if you heard the full context, it would actually help his case.
Okay, so we've got a key witness recanting, alleged deals being revealed, and now claims that the audio evidence itself was tampered with or selectively presented.
Exactly. And there's another specific point, too, about the Endangered Species Act charges. A key government claim at trial was that Maldonado-Passage sold a tiger cub to someone named Ivan Brown. But the motion says after the trial, this Ivan Brown came forward. He submitted a statement saying he had never purchased such a cub, nor even been in the area during the period in question.
So another factual claim from the trial now being directly contradicted by the person involved.
Correct. And the motion uses this to argue it's undeniable that part of the government's allegations at trial were based on a false narrative.
So when you put all that together, Glover's recantation, the questions about the recordings, this Ivan Brown statement, it paints a picture of a conviction built on, well, shaky ground, according to this motion.
That's precisely the argument they're making, that the foundation of the conviction is crumbling under the weight of this new information. And it raises that crucial legal question. If the facts presented at trial turn out to be false or manipulated, What happens next? How does the system correct itself?
Right. It's not just about Joe Exotic, it's about the integrity of the process. And this motion doesn't stop at just presenting new facts. It goes further, right? It directly attacks the previous appellate ruling itself.
Yes, it does. This is where it gets quite pointed. The motion explicitly argues that the panel's previous opinion inexplicably contains false statements of fact which are not consistent with the record or other evidence of the case. That's strong language to use about a court ruling.
Very strong. Do they give examples?
They do. One key example involves a cell phone supposedly shipped to Las Vegas. The panel's opinion stated, and I'll read a bit, before Glover left for Florida, Maldonado gave him an envelope stuffed with cash. Maldonado also took Glover's phone and shipped it overnight to Las Vegas, where Lowe received the phone and used it occasionally so that the phone's location would register there and cover up Glover's true location.
Okay, seems like a specific detail establishing part of the conspiracy.
Right. But the motion calls this plainly untrue. It cites newly discovered evidence, specifically an affidavit from Lauren Lowe, who apparently now admits that she never opened such a package and that the overnight package she received may not have contained any cell phone at all.
Huh. So the story about the phone being used as an alibi might just fall apart based on her new statement.
That's what the motion suggests. Another point is about text messages. The panel stated that the undercover informant, Garretson, turned over these phone calls along with several text messages to the government.
Okay, standard procedure, you'd think.
But Maldonado-Passage's motion claims Garretson did not turn over many important relevant text messages, and the withheld messages undermine and reveal context which is exculpatory for Maldonado, as Garretson now readily admits.
Whoa. So Garretson himself now admits he held back texts that would have helped Maldonado. That sounds like a Giglio issue, potentially.
It certainly raises that flag. Withholding evidence that could impeach a government informant is a serious allegation. And then there's this trust conversation. The panel described a key exchange where Maldonado supposedly expressed reservations about using an undercover agent as a hitman, asking Garretson if they could trust him.
Right, making Maldonado sound like he's vetting the hitman.
Exactly. But the motion claims the actual recording shows something different, something profoundly important. It says Maldonado-Passage asked Garretson if Garretson thought he could trust the hitman. Garretson apparently replies, oh, freaking 100%.
Oh, okay, so Maldonado isn't asking they can trust the hitman, but if Garretson trusts the hitman.
That's the argument. And they say this reframes Maldonado as just a mere passive and dubious chit-chatter, while Garretson was the one introducing, driving, and propounding the murder-for-hire idea.
That changes the dynamic completely. From potential mastermind to maybe just a bystander caught in someone else's scheme.
That's the picture the motion attempts to paint with this recontextualization. It really shows how interpretation and selective presentation can matter so much.
Absolutely. Okay, so we've covered the new evidence, the alleged falsehoods in the prior ruling. Now let's get into the weeds a bit, the legal arguments about standards and procedures. This is where it gets technical, but it's crucial.
It really is. Because this isn't just about facts, it's about how the law applies to those facts, especially after a trial. One major battleground is this thing called the invited error doctrine and the standard for granting a new trial based on new evidence.
Okay, break that down. Invited error.
Right. The panel basically said Maldonado-Passage couldn't complain about the legal standard used for his new trial motion because his own initial motion mentioned something called the Berry test. The Berry test sets a pretty high bar. It asks us if the new evidence makes an acquittal probable.
So the panel said, you mentioned the Berry test first, so you're stuck with that high standard, even if it might be the wrong one.
Yeah, it's the gist of the panel's reasoning, yeah.
Yeah.
But Maldonado-Passage's lawyers argue, hold on, our appellate brief specifically challenged this. They claim the district court used the Berry test as a figurative battering ram, just repeating probable acquittal over and over.
And they're saying the law is more complex.
Exactly. They argue that the law is actually much more nuanced, especially when the new evidence involves a witness admitting to perjury. In those cases, they argue, a lower standard should apply, often called the Larison rule.
Okay, Larison rule, what's the difference?
The Larison rule generally says a new trial might be warranted if the false testimony was important and a jury might have reached a different conclusion without it. See the difference? Not probable acquittal, but just might have been different. It recognizes that perjury kind of poisons the well.
That's a much lower bar. So the fight is about which test applies when a key witness recants.
Precisely. And whether mentioning the Berry test once means you can't argue for the Larison standard later, especially if you think the court is misapplying the law.
Okay, that makes sense. What other procedural arguments are they making?
Another big one is the right to an evidentiary hearing. Remember Glover and Garretson admitting to perjury or undisclosed deals. The district court denied a hearing to actually question them about these new statements, to assess their credibility face-to-face. The panel upheld that denial.
But shouldn't a judge want to hear from witnesses who say they lied under oath?
You'd think so. And the motion argues this denial goes against established 10th Circuit precedent. They cite cases like United States v. Page and Ramsey, which they say ordinarily require an evidentiary hearing to evaluate both the credibility and impact of a recantation.
Especially when it's not just rumors, but sworn statements.
Right. The motion stresses these weren't just casual remarks. They were mostly in sworn affidavits, in detail and under oath, and supposedly backed by other evidence. They criticized the lower court for basically deciding who was telling the truth, the recanting witnesses, or, say, an FBI agent who filed a counteraffidavit without actually holding a hearing, giving itself an unheard-of level of discretion, as the motion puts it.
So they're saying the court acted as judge and jury on credibility without the proper process.
That's the core of that argument. Then tying back to the withheld evidence.
The Brady and Giglio stuff we touched on earlier.
Yes. The motion claims the panel got it wrong by not finding Brady or Giglio violations, despite the new evidence suggesting undisclosed immunity or benefits for witnesses like Glover and Garretson. They argued the panel demanded too high a level of proof, a heightened showing of materiality and credibility that doesn't line up with Supreme Court cases like Kyles v. Whitley.
And Kyles
basically says you have to look at the cumulative effect. You don't look at each piece of withheld evidence in isolation and ask, would this one thing have changed the outcome? You have to look at all the suppressed evidence together and ask, taken as a whole, does this undermine confidence in the verdict?
Okay, so piece by piece might seem small, but added up, it could be significant.
Exactly. The motion argues the panel failed to do that cumulative analysis properly.
Got it. Any other major legal points? You mentioned the Endangered Species Act counts earlier, too.
Yeah, briefly. The motion argues the panel used an overly restrictive interpretation of what counts as newly discovered evidence regarding the killing of 5 tigers. It claims the panel ignored statements made after the trial and didn't properly consider evidence suggesting the government only dug up the skulls, potentially hiding other evidence that might have supported Maldonado-Passage's defense about how those tigers died.
Okay. And the last point was about entrapment, right? The panel said he waived it.
Right. The panel concluded he never properly raised an entrapment defense, so he lost the chance to argue it. But the motion pushes back, saying, well, first, entrapment evidence isn't just for an entrapment defense. It can also show someone lacked criminal intent or was just engaging in innocent puffery.
Like big talk that wasn't serious.
Kind of. And they claim the government withheld evidence showing his noteworthy remarks about murder for hire were actually spurred, provoked, and fueled by friends acting undercover, making the discussions utterly hypothetical. Crucially, they point out Maldonado-Passage did testify about entrapment at trial, but he had no proof then. Now they argue the newly discovered evidence like Garretson's potential role in pushing the scheme corroborates his trial testimony.
So the new evidence bolsters a defense he tried to raise but couldn't back up at the time.
That's the argument, that the new evidence doesn't just potentially show perjury, but also potentially supports his claim of being set up and therefore innocent.
Wow. Okay, so pulling this all together, this deep dive into Joseph Maldonado-Passage's motion for rehearing really highlights the layers and complexities of the appellate process. It's not just a simple review, it's digging into fundamental questions.
Absolutely. The motion frames this case as presenting critical questions about post-trial rights, prosecutorial misconduct, and the proper handling of recanted testimony. Heavy stuff. They argue the panel's decision, if it stands, undermines the ability of defendants to obtain relief even where compelling new evidence arises, end quote. And they wrap up by saying the full court needs to rehear the case, the Banc rehearing, to keep things consistent with Supreme Court and their own circuit's past rulings, and importantly, to preserve public confidence in the integrity of the judicial process.
So for you listening, what really stands out here, beyond the whole Tiger King phenomenon in the headlines, what does this dense legal filing actually tell us about the challenges of ensuring a fair trial, about the burden of proof, and how dramatically new information can potentially reshape how we see a case even years down the line?
Yeah, think about how these shifting stories from key witnesses, these allegations of hidden evidence, how that might impact your trust or anyone's trust in how legal proceedings work. It's more than just this one, very public individual's fight. It really does open a window into some fundamental questions about justice, truth, and how our legal system grapples with both when they seem to collide.